eNCA board chair Dudu Myeni was in court today fighting against being declared a delinquent director. She brought an application to court citing the testimony of former board member Yakhe Kwinana. Now let's get the latest from our reporter Heidi Jakas, who's been following the story for us. So Heidi, a number of applications brought by both parties. Let's touch on what eNCA is asking for as Dudu Myeni tries to appeal.
Yes, most certainly, Shahan. So we do know that Dudu Myeni's legal team, they've put two applications forward, and a leave to appeal of the order that was handed down earlier this year declaring Dudu Myeni a delinquent director for life, and an interlocutory application. But what eNCA has asked for on the back of the leave to appeal application, eNCA wants an enforcement order. And basically what this will mean, if it is granted, is that despite the fact that there is an application for leave to appeal, and if that application is granted or not, eNCA wants the court to enforce the order and to make sure that Dudu Myeni does not have any directorship in any company. eNCA is saying that just looking at the evidence that's been presented with regards to the conduct and the dishonesty and the gross negligence of Dudu Myeni, according to eNCA, while she was at SAA, they believe that she should not have any directorship in any other company. And we do know that she is a director in one state-owned entity, and eNCA is very concerned about this, saying that they do not want her to hold any further directorship, and that's why they want an enforcement order. Let's listen to what eNCA said today in court.
Can it be in the interests of justice and in the public interest to allow Ms. Myeni to remain in fiduciary positions of public trust, earning public money for those 3 to 4 years, in circumstances where she's been found to be dishonest, not only in her dealings at SAA, but with this court? Findings of dishonesty, findings of recklessness, findings of gross negligence, which remain largely uncontested. And again, I remind you, Ladyship, the finding of dishonesty about Ms. Myeni's conduct in this case is not subject to any application of leave to appeal.
Naturally, Dudu Myeni's legal team against an enforcement order, saying this will cause serious harm.
Exactly. So we do know her senior counsel, Dudu has indicated that they have put in an application for leave to appeal. They are saying that it's important for perhaps another court to look at the order that was handed down by Judge Ronald Talme earlier this year. And Dudu basically saying that they believe another set of eyes could come to another conclusion, also indicating that it's going to cause serious harm for Dudu Myeni should she be declared a delinquent director for life, as she still holds directorship in 4 companies. But what's interesting here, Shahan, is the fact that Dudu Myeni indicated during her trial that she had no money and she was not employed. And when eNCA's legal team indicated to her that she still holds directorship in 4 companies, and they brought out those figures as to what she's still being paid in board fees, Dudu Myeni said that that was nothing but a stipend. And Dudu, of course, trying to defend that statement, saying that it is actually money that comes in for her, and if she does not get that directorship fee, she's going to go hungry. So let's listen to what Dudu had to say about that.
The point we were making is that any party, whichever one, whether you come as a winner or as a loser, this is a matter, it's self-evident from its own nature, which is fraught with all sorts of byways and highways. And it's a matter that's not going to end tomorrow, and therefore...
But is that with the application for leave to appeal now, Mr.
No. No, my lady. Again, I'm addressing what Mr. McConaughey was saying to you this morning about the fate of the matter. Remember, when your ladyship weighs the irreparable harm, you have to postulate into the future. That's the only... That harm, all I'm saying is that harm might take 3 or 4 years. Really, that's all I'm saying. And if you say why, it's because either us or them might appeal or counter-appeal or whatever at the next levels. So it's only in the context of Section 18 that your ladyship must say, if this was a case that's going to end next week, your ladyship might say, well, so what if there's a harm for a week? But I'm demonstrating that the harm will endure for a number of years, because whether it's them or us, this case is not going to end here. And that's not a threat.
And the judge, of course, under immense pressure as these are extremely urgent applications.
Most definitely, Sean. She has 4 applications in front of her that she needs to consider, and she's under immense pressure to come to some kind of ruling before the end of the 4th term, before court goes on recess. So we know that that is at about the 13th or the 15th of December, where court goes on recess, and she's indicated to both parties that she understands the urgency, and she's going to try her utmost best to provide some kind of ruling, and that will be emailed to parties.
All right, we'll leave it right there. Heidi Jokos.